My name is David Postolski. I'm a partner at Gearhart Law. I've been a IP and patent attorney for almost 20 years, and uh, f- many years into my practice, decided that I wanted to devote my life to entrepreneurs. And luckily, I had the honor of meeting Richard Gearhart, who was, I guess, kind of going through a similar journey with that I described. Anyway, I think Richard was having a very similar journey to me. You'll hear from him in a second. And so it was great to kind of meet, and here we are today. So without further ado, I want to introduce my partner, Richard Gearhart, and maybe you can do a little bit of an intro, Rich.
Sure. Well, thanks for putting this together, David. You've been doing this for a couple of years now, and it's been to absolutely rave reviews. And I think it demonstrates your commitment and the firm's commitment to the entrepreneurial journey. And we at Gearhart Law are very supportive of entrepreneurs. When I left the large corporate environment, I made it my mission to try to start and help at least 500 companies start and and become viable business entities. And we're way past that now. Gearhart Law is close to 5,000 clients. Most of them are entrepreneurs, or at least entrepreneurs in spirit. And we're very proud of the work that we do for our clients, and we're very grateful for the support that they give us. And we're thrilled about being able to support them as well. So thank you very much for coming. And I'm looking forward to this. We did it last year. It was a lot of fun. This is not something that we should take so seriously. I think David was the one who created the quiz format for this. So we're very anxious to have your participation in answering the questions. So I think the way it's going to work is David's going to put the question out there, then you get to put your thoughts in the chat, and then we'll talk about the answer, right? So David, why don't you go ahead and take it away? Take it from here.
That's it. That's it exactly. Rich said it perfectly. We are going to show you a myth, and we want you to chat us as to whether you think it was factor. Sometimes it will say factor fiction, so you let us know if it's factor fiction. Sometimes it will say myth or truth, and just let us know if you think it's a myth or a truth. So first one, we're going to start with some easy ones for some, just FYI. A trademark protects an invention. Myth or truth? Chat us what you think. Myth or truth? A trademark protects an invention. By the way, all of these are real statements that have been communicated to us by various potential clients or actual clients. And so that's why we chose them. A trademark protects an invention. Here comes the answers. Myth, 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 myth. Somebody wrote truth with a question mark. That's interesting. Okay, yes. And so the answer, and we'll go into a little bit of a brief explanation, but yes, a trademark does not protect an invention. Um, what does a trademark protect, Rich?
Well, it's a source identifier, and it protects a brand or a company name. So it protects your brand. And
Oh,
that's, effectively what a trademark does. Um, and so sometimes there is confusion between patents and trademarks. I mean, the way the question was asked, a trademark could also protect an invention, but it would protect the name of the invention as opposed to the substance or the technology associated with the invention. So, trademark could protect Coca-Cola, but it wouldn't protect, but it only protects the name. It doesn't protect the formulation, right? So.
yes. Along those lines, again, these are a few easy ones just to get you a little bit warmed up. Here's,
And as usual, I had to make it more complicated than it really was. So,
yeah, we should definitely go by just the words on the screen for sure. But here's the second one. A copyright protects a brand name. Again, most IP attorneys would probably tear this statement apart, but what do you think? A copyright protects a brand name. Myth or truth? Myth, 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 myth. Let's just say you better get these right, right? These this one too. So a copyright protects a brand name. That is a myth, right? What is a copyright? Go for it, Rich.
Well, it protects original works of expression like movies, music, uh, literature, sculpture. And so copyright is different from a trademark that protects a brand.
Yeah, again, you'd be surprised how many people have said these statements to us, which is why we put them up. So a patent is not a trademark, is not a copyright. And so again, the last kind of easier ones is, and you hopefully already know this, a patent protects a slogan. Myth or truth? By now, you should probably already know the answer to this. A patent protects a slogan. Myth or truth? Well, thankfully, everybody that is participating is getting it right. So say that's a good thing. But yes, a patent. So a patent protects slogan. That is a myth. What does a patent protect?
Technology, basically, or an invention. So, which again is very different than a patent and I'm sorry, a copyright and a trademark. So,
Correct. Patents are based in science, physics, chemistry, biology, mechanics, electrics, computer science, biology, geology, anything you can, even design. Trademark, as you heard before, protects something that is a source identifier. The moment you start selling something, commerce, when you start selling something and you want to name it something, you want to name that product something, you want your company to be named something, that is a trademark. Patents have nothing to do with commerce. Copyrights have nothing to do with commerce. Trademarks are all about buying and selling of goods and services. And a copyright, as you heard from Rich, is the creative and artistic expressions that you try to protect. Stuff based in literature, choreography, sculpture, stuff like that. So very three distinct protections, often confused by many people. But that was just to kind of warm you up. Let's get into the real meat of this. IP rights are based in the US Constitution. The intellectual property rights are based in the
Oh
United
no, we're not doing this.
Constitution.
uh-oh, constitutional law. Mm.
We are not doing, yeah. We definitely going to talk about the Constitution. What does everybody think? Peter says truth. What does everybody else think? Yasna says myth. Interesting. Anybody else? There are no wrong, well, there are wrong answers, but but we encourage you to still let us know. Myth from it's funny that person's name is Intellectual Property Myths. They didn't name themselves. Um, myth. I may put some of you people on the spot a little bit. And I imagine the people that didn't answer whether it was a myth or truth probably just don't know. And so IP rights are based in the US Constitution. The answer is truth. In 1790, when the US Constitution was created, that's a long time ago, there is something called the Intellectual Property Clause. It's basically what America was built on. The Constitution literally has the right of copyright and patent in this clause. I probably should have put it up here, but you can just Google it very quickly now. It's called the Intellectual Property Clause. Yeah, go for it. It's Rich.
No, I was going to say Article 1, Section 8, Clause 8 of the
Yes.
Constitution. And I didn't know that, by the way. I knew it was in the Constitution, but while David was talking, I Googled it and I found the right answer. So that way I get to sound like an expert.
I always say this, when the Constitution was written in 1790, it was not written by like Google, Dell, Oracle, even AT&T or Bell Labs or anything like that. These were people. There was nothing in this country in 1790. We had just declared independence from Britain, and America, the new America, our founding fathers who wrote the Constitution, wanted to make sure that we embedded in the fabric of our society the right of intellectual property, which said that if you have a great idea for an invention, we have a great idea for a writing, share it with us, share it with the government. In exchange, we will give you the exclusive right to protect that invention or that writing. And so that it is definitely in the Constitution. It's how America was industrialized. And so it is the fabric of innovation. And by the way, that's only two of the three forms of intellectual property. So the clause that Richard read, this Article 1, Section 8, what is it?
Okay.
Yeah, clause 8. That talks about patents and trademarks. You see the words invention and discovery, you see the words authors and writings, but there's another, right? The trademark, that's also in our Constitution. That comes from the Commerce Clause, right? You all know about the Commerce Clause. That's also in our Constitution. The Commerce Clause says that the government has the right to say that if you are going to sell a good or a service in commerce, that you as a company have the right to be called your name, and only you have the right. You have the exclusive right to call yourself that company name if you tell the government what your company name is, and in exchange, they give you a federal right of trademark. So, yes, intellectual property rights are based in the US Constitution. All intellectual property rights are based in the Constitution. So, keep that in mind as you move forward. Yes, Jocelyn, in defense, you are Canadian. And to be perfectly honest, many countries in the world that either have a constitution or have some declaration of independence do not put it in their constitutions. But this is kind of why America was created. And so, yeah, we won't blame you for being from Canada. We do love Canada. Okay. If I own the copyright registration on a logo, then I also own the trademark on that logo. Wow, I cannot tell you how. I would say once a day, I probably get an email from a potential client or a client that says, I have a logo, it's amazing. I have to file my copyright on it. So myth or truth? If I own the copyright logo, then I also own the trademark on that logo. Myth or truth? What do you think? Any truths out there? I didn't write them in a way to make it confusing, but I'm sure, Rich, you're probably going to be you may you may tear that apart a little bit. But if I own the copyright registration on a logo, then I also own the trademark on that logo. Myth or truth? Myth. Maybe you want to break it down a little bit, Rich.
Well, I mean, so if you can go back to the
To the question, yeah,
question
the
real
statement.
quick. I mean, first of all, this is complicated stuff, and it's not unusual for people who don't deal with it every day to you be unsure about how certain words are used in certain legal concepts. So, um, so I would never criticize anybody, even professionals, if sometimes they mix things up a little bit. Um, so, but really, copyrights and trademarks are two separate legal ideas. And so, if you want a trademark, you have to go through the trademark process. Copyrights are a little different in that you get a copyright automatically when you create the work. And so you can register a copyright. And in a lot of cases, it's desirable to register that, but you don't have to, right?
But you can.
And so they're really two different types of intellectual property, and they really don't overlap. So
Yeah,
that's my
I,
answer.
no, that's good. I kind
Final
of,
answer.
yeah, I think we can maybe break it down a little bit more just to let people know, just to kind of go off of what Rich said so if you sit down with your pad and paper and you create a logo, you literally draw it out, or maybe have someone draw it for you, then you as the creator of that logo that you drew out literally own the copyright. It's automatic. The only thing that you have to do, and it's a really important it's an important step that a lot of entrepreneurs miss, is you have to take that drawing that you automatically own the copyright on it and literally register it with the United States Copyright Office or any other copyright office that has copyright laws in the world. That registration allows you the ability to go after someone, to literally say, like, this is my property, right? The problem with the registration process of a copyright, unlike what Rich said with a trademark, is that there is no examination. There are just millions and millions of different types of creative and artistic works that are available for copyright registration. So it's inconceivable for the United States Copyright Office to literally examine your logo to determine if your logo was actually original, meaning you were the first to create it. The copyright registration process does not involve that. It is literally they are opening up a file for you, putting your name on it, putting in that work, and they are literally putting it in their library. It's called the Library of Congress. They're not looking to see if other people have created a similar logo. But if you take that logo and then you apply that logo to a product or a service that you are offering for sale in commerce, in interstate commerce, then you apply for a trademark. And that process, as Rich said, that's a process. That's an examination process. Somebody will be assigned to it, a trademark attorney that works for the government, and they will look, and they will look to see if there are other logos that are similar to yours. It will go through an examination process, and if you can prove that your logo was truly, the first and not confusingly similar to another one, then you will get the actual trademark for it. And so it's not so basically you need both, is what we're trying to say. You definitely should register your original creative artistic work on your logo, but the moment you take that logo and you put it on a product or a service, then it goes through some examination where then it will be determined whether you were the first to create that logo or not. The copyright registration process will not do that for you. So you might need both. Okay. By the way, if there are any questions on anything like this, just let us know if you can. Yeah, Lucy, what about copywriting artwork? That's the example I just said now, right? If you creating a logo, that's artwork. You take that artwork and you register it as a copyright. But if you're going to take that artwork and you're going to use it as the symbol for your company or the symbol for your product or service, then you should be also filing a trademark application on it as well. Okay.
Okay.
Thank you, Lucy. Next one. Businesses own all intellectual property created by employees and contractors if there is an agreement stating they do. So a business will own all intellectual property created by their employees and contractors if there is an agreement stating that they do. Myth or truth? This is a big one. Truth. Myth. Gina says truth. Charles says myth. Interesting. Anybody else? Truth or myth? Charles, I'm going to put you on the spot if you sign it. Yes, Michael Remian. Correct. You definitely need a signed agreement for sure. That's a prerequisite. Charles, I'll put you on the spot a little bit. Why do you think it's a myth? If you can,
Just your wording there. We're talking about uh, im- uh, intellectual property created for the company, or you're talking about intellectual property that you've created yourself outside of the company, in which case I believe fair trade laws apply.
that's interesting, Charles. Yes, I think you're also. I think that that's a valid point. This statement is more along the lines of I have an employee, I have a contractor, I am a business. I have an employee, I have a contractor. Whatever those employees and contractors are doing for whatever they're creating, whatever intellectual property they're creating for my business, I own it if there is an agreement stating that. So if anybody want to change their answer or update it, there's some really good comments in here, Rich. But I think I think you're right. I think in the way that I worded it, maybe it was a little bit. I'm hoping it wasn't so deceiving, but it is the truth. Maybe you want to break ownership down a little bit, Rich.
Sure. I think, what David said is right to the extent that the invention was created on company time using company resources and, in general falls within the scope of activities that the company engages in. Lots of times these clauses are written broadly. And having worked at Novartis, I used to write a lot of these clauses. But even though there are clauses in these contracts that you sign, there are also state laws that actually favor the employee a little bit over the employer. So lots of times what it'll come down to also is, what is your role in the company and what were you hired for? So if you were hired to be a scientist and create new chemical compositions, but then in your spare time, you like to experiment, or you like pets and you create a pet product. You weren't really hired by the company to create pet products. You were hired to do research, right? So in that case, even if you had a very expansive clause in your employment contract, you would probably be legally entitled to pursue that invention. But it's a very tricky question. Sometimes we do get clients who have inventions that they create when they're at work. And, and so you have to kind of take the politics into account there because, and you have to kind of take the temperature of your employer, right? And so some employers don't really care that much if you pursue inventions outside of work. Some care a lot. And so it's actually, if you find yourself in the spot, I think it's kind of a definitely kind of a complicated fact issue, and that you should get some legal advice on what is the best way to handle it. So we've actually had clients who were fired from their jobs for pursuing sort of related inventions, and the company wanted to make an example out of them. We've also have a lot of clients who are able to kind of walk that line. But my advice usually is if there's a question, get permission from your lawyer or from your employer if you care about keeping your job. So that's kind of the bottom line. I don't know. I kind of beat that one to death, but
No, I
it's
think that
one that we've seen a lot, and you have to be careful if you're in this territory. So
yeah, 100%, Rich. It is definitely a moving target. So for all of the businesses that are represented on this call, and for all the people that are going to be hiring people, for all the people that are going to be hiring employees or hiring contractors, or for those of you that are the employees and or the contractors and you're unsure, this is a complete moving target. And it really is very fact specific. And it really depends on whether there is an agreement or there's not an agreement, what their expectations are, everything that Rich said. And so we don't assume nothing in this,
Right.
because the law is all over the place for sure. But
Yeah.
I use the word employee for a reason. If you are considered an employee, there is definitely a higher obligation, if you will, to your employer, meaning they likely will own everything. A contractor, that's a totally different type of designation for somebody that's helping out in a company. And again, most contractors are hired to do something that is owned by the business, but there are plenty of contractors that exempt a lot of the intellectual property rights that they want for themselves. So it is a moving target. Yeah, Rich.
So I would also add, though, if you're an entrepreneur and you're working with vendors, you always want to make sure that you have an understanding around who's going to own what at the end of the contract, and that needs to be in writing. So a lot of times our clients will get in disputes with vendors because there's a misunderstanding about who's going to own the copyright or who is going to own the work product, and then what the vendor can do with the work product after the relationship is over. So all of those things, it's very important to make sure all of those things are clear, and there's like no necessarily right way to do it. It's just a matter of making sure that everybody knows what's going to happen and that they agree to it at the outset, rather than not discussing it and having problems later on.
Awesome. Perfect. Well said. Okay, let's move on. Again, any questions you can put in the chat. Okay. This might be, hopefully it's not a double negative. I cannot just use any work or image I find on the internet, especially if it doesn't have the copyright symbol. Cannot just use any work or image on the internet if I find it on the internet. So basically, you're on the internet and you find an image. Can you just use it if it doesn't have a copyright symbol? Myth or truth?
Mm. We should have like a little background music going as
I
we
know.
wait for people to.
I love
If
Gina's
we do
answer.
a third
Risky.
version of this, we need background music.
We do next time. I love Gina's answer. Risky. I love that. That's great. Truth. I can't just use an image. Yasna, I'm going to put you on the spot a little bit. So you think this is a myth? You think you can just use any work or image that's on the internet, even if it's not marked with a copyright symbol?
Hold on. No, I misunderstood.
Okay, that's okay.
My brain went backwards. Sorry.
That's okay. Yes, this is the truth, right? You can't just use images that you see on the internet. Um, we actually have built an entire entrepreneurial strategy series that you're going to be hearing in a few months, because a lot of our clients that will just randomly use images from the internet are normally getting cease and desist letters from the large companies that own those images. And those companies don't really care that you didn't know that you can't use it, or that you were innocently using it. They don't care. They will literally send you a cease and desist letter, and they will say you need to pay us a license or some sort of royalty in order to use that image. So I say this all the time. I mean, this is like a rampant problem in the world, given, social media and just the constant, like, puking of information that exists in our world. People will just use anything they find on the internet to their own advantage. And that's not a good thing. That is technically infringement, right?
Right.
That is technically using somebody else's property. And you have to assume it kind of goes both ways. I'll turn over to Rich in a second, but it kind of goes both ways. For all of you that are creating intellectual property and want others to respect your intellectual property, think of that all the time when you are on the internet and you are searching for something and you want to use it. You need to know that that image was owned by someone. And yes, it maybe got out into the internet and you think it's free to use, maybe, but it may not be. And so the same respect you want for the intellectual property you're creating should be the same respect that you should be giving to others who have created intellectual property. Rich, any thoughts?
Yeah, no, well said, David. I would only add that there is an industry that's kind of building up around policing photographs on the internet. So you have law firms that have some sort of search software, or you have companies, policing companies that are able to search the internet and find people who are using pictures that they're not authorized to use, and then that information gets transmitted to a law firm, and they have sort of this boilerplate complaint, legal complaint that they'll send to the purported infringer, and they'll ask for $20,000, right? And then usually they can be negotiated down. Usually they don't file a lawsuit over a single image that's infringing or potentially infringing. But it's a big hassle for the person who receives this letter. And lots of times, like David said, they're just surprised. So even if there's no copyright symbol, if you're putting together any kind of work that involves photography or, quotes, text quotes, make sure you get permission from the source or you purchase it, right? And before you use it. And if you're having, for example, a website built, you want to make sure that the company that's building your website has the rights and the photographs to actually use them on your website, because you don't want to, if they're sloppy and they take images that are unauthorized, you could be responsible for that. So you definitely, whenever you're creating something like a website, you want to make sure that you have the right permissions to use the photographs and any text. So.
Excellent. Stephen, I'm going to put you on the spot a little bit. Stephen will be kind of handling our ESS on this topic of copyright trolls, if you will. Maybe you want to say a few thoughts?
Yeah, sure. I mean, I basically, I guess I kind of want to echo what Richard was saying, is that it's really become a a kind of a kind of industry for a lot of for law firms that have been popping up, built around policing one company's like giant database of images, and they will be sending, dozens or hundreds of these letters out to, small individual entrepreneurs, or even people that, aren't even making money off of their websites, just to try and, send out as many letters as possible and get as much of a chance of one person in 100 paying them out a couple $1,000s. And so you really want to be careful, because if you receive one of these letters, you really need to respond to it, otherwise risking a lawsuit. I mean, like Richard said, we don't know that they will 100% file it, but if they're within their rights to file it, you're really better safe than sorry in this kind of situation. So 100% cover all your bases. Make sure if you are building a website, don't just take any image you find out online. If you search something on Google Images, just because it's on there doesn't mean you're free to use it. Um, people could, and especially lately have been coming after you, after people. So
I can't,
yeah.
thanks, Stephen. I can't resist telling a quick story. A local library got hit with one of these cease and desist letters, and which is what I found interesting, because number one, you would think libraries are copyright aware, but number two, they don't care who they send these cease and desist letters to, because a library is usually a nonprofit, but doesn't matter. So just beware of this, but that's why we're here, to make you aware. So
Yeah, and then I want to just go to two of the questions from Peter. It's a good one because it's good best practices. Are there sources on the internet, that images on the internet that are open for use? There are. There's a few places that you can go to. The first is called creativecommons.org, I think, or .com. Check it out. Basically, is a library of there's a library of images and musics and everything that is available for public consumption under certain terms, under certain licensing terms. You just got to agree to those terms and you can use whatever you want. So there's really no excuse. Another thing is, there are some sites that list images and songs and anything that could potentially be copyrighted that are in the public domain, meaning the copyright protection has run out. And so there are sites that you can search if the copyright has run out and or what is in the public domain. So again, from a court's perspective, there's no excuse that you should be committing unintentional or innocent copyright infringement. And so that's why we want to try to avoid this type of behavior, because you might really be on the hook. Yes, Rich.
Yeah, I was just going to mention too, if you're a content creator and you're working on social media, a lot of the social media sites are now policing music. So if you're creating a Instagram reel and you're using the Rolling Stones, they have an algorithm that will find that, and it's especially true in YouTube. If you're putting YouTube videos out and using copyrighted music without authorization, you'll get a copyright strike, and they keep track of that, and it affects your rankings and whether you can monetize the video or not. So I think what David is saying is absolutely correct. It's worth a little time to make sure what you're using is in the public domain or it's something you create yourself. So
Right on. And then lastly, Lucy has a good question. We're not going to get into it so much, Lucy. What about AI created images by prompt engineering? Can they be copyrighted? We had a whole entrepreneurial strategy series on artificial intelligence and how it relates to intellectual property, particularly your exact question. And so know that the short answer is no, it cannot be copyrighted. A copyright must be created by a human being. That has come down from the Copyright Office. That's where we are right now in the world. That may change in the future, but if you created an image through artificial intelligence, ChatGPT or Bing or any of them, that image, if you applied for a copyright, would likely, more than likely, be rejected because a human being didn't create it. Yes, the prompt was made by a human being, but the actual image was made by artificial intelligence. And so we spent an hour and a half kind of speaking about this. Check that out on our YouTube site. It's all about artificial intelligence and intellectual property. And actually, Stephen was one of the presenters. Okay, we get this a lot. I can only use the trademark symbol if I have achieved a trademark registration. Fact or fiction? I can only use the circle R symbol if I have achieved a trademark registration. Fact or fiction? What do you think? Truth? Anybody else think it's a myth? I can use whatever symbol I want. I can use the circle R anytime I feel like it. Yasna, did you want to comment on your myth for a second? Oh my God. Okay, so that I can only use the trademark symbol if I achieved a trademark registration. That is fact. This is huge, people. I cannot tell you how many times that a person, when we apply for a trademark registration, we apply for an application, meaning it hasn't been registered yet, the client will literally send me their trademark with the little circle R in the corner. And the first thing we have to tell them is stop using the circle R. That is the symbol that you can only use if it is awarded to you by the trademark office. In fact, using the circle R when you do not have a registered trademark is called false marking. False marking. It is against the law to do that. You cannot purport yourself to have a registered trademark if you do not have a registered trademark somewhere in the world. You can use the TM symbol. That's for everybody to use. That little TM, that you can all use. And anybody can use that. And you can use it if you file for a trademark or you haven't filed for a trademark. But you can only use the circle R if you have gone through the examination process with the trademark office and they have awarded you the circle R. Any comments or thoughts, Rich, on that?
No, I mean, that pretty much nailed it. I would say sometimes our clients have the opposite problem. They don't use the registration symbol enough. So, so once you get it, you can't use it before you get it, but then after you get it, you need to use it, right? So anywhere you're using your trademark, you want to make sure that you have the registration symbol associated with it as much as possible, right? And because otherwise you lose rights if you're not using the registration symbol. So
But Rich,
so
can
make sure that once you get it, you use it, right?
yeah, Rich,
And
can you answer the other question by Michael Remian? What about the circle C? I think that's what causes a lot of confusion with, you know.
yeah, I mean, it's interesting. It's so now we're moving into the world of copyright. So we were talking about trademarks before, right? So we're moving into the world of copyright. I always recommend using C. It's not legally necessary anymore. The law changed on that a while ago, but I think it's helpful to put people on notice that you consider this your property and that it's important enough to put other people on notice that you don't want them to use this property, right? So that's part of the value of intellectual property is putting other people on notice that you're making a claim to this copyright, and that acts as a deterrent. So I would definitely use the copyright symbol when I can.
Yeah, no, I think my point was also that because the circle C is something that you can use regardless of whether you have a registration or not, that I think seeped into the mindset of brand owners as well, of like, oh, that means I can just use the circle R because I can also use the circle C. No, the circle R is definitely something you can only use if you've been registered. And to Peter's question, why can you use the TM if you can't use the circle R? I mean, it's just Peter, it's just the rule. Basically, it's just like a law that says that TM is the symbol that you use when you don't have a registration. The circle R is the symbol that you use when you do have a registration. So it's just a matter of, you know, using it in the right way. But to Rich's point, if you, which I like, which is that people when they have a registration, a trademark registration, they're not using the circle R, but they really should be using the circle R because it definitely puts the world on notice that that you have a registration. And so when you're thinking about like infringement, you know, sometimes courts look at that like, oh, you knew it was a registered trademark and you went out of your way. It was marked, right? It was marked with the circle R, and you went out of your way and you still infringed it. And for that, court could possibly punish you. And so Michael Remian has a related question, Rich. How do we protect images of our product before the product has been awarded patent? There's a lot going on there, Michael.
So there's two different ideas there. One is protecting the technology, and that you would do that with a patent. And you know, our general approach is that once a patent is filed and your patent pending, you can move forward with the commercialization, right? Now, images of the product, that's different. That's copyright, right? And so those images are protected as soon as you create them. So of course, the timing of when you publish any images needs to be, you need to consider the patent process before you publish any images of your product if the goal is to file a patent, right? So you have to, in general, you want to file the patent first, and then you can publish pictures after the patent application is filed. But that's really two different types of protection. You don't really get protection for the invention by publishing pictures. You only get protection for the actual picture, the way, the sort of the artistry that goes into making that photograph. So I hope that answered your question.
Yeah, it's interesting, Rich. I think the question and your answer just illustrates how different these intellectual property protections are. Gina has a very similar question that's also kind of illustrates some of the confusion of like what type of protection is most necessary and appropriate. What if I published a book with a concept that is marked with trademark? So that's already something that may not be a proper statement. We'll explain in a second. What if I published a book with a concept that is marked with trademark? Once I get the copyright, do I have to republish the book with the circle R symbol? So yeah, Gina, I think your question illustrates that there's that. Well, Rich, do you want to answer that? Because it's like because I mean we love you, Gina, but like that question just I think illustrates that there's some confusion for sure between trademark and copyright, you know?
Right. So it's you can in general you can get a trademark on the title of a book, right? And if the trademark isn't granted when the book publishes, uh, I would generally try to use the registration symbol with the title if there's a second publishing. If it's an ebook and you can update the title with the registration symbol, I would do that. But the protection for the story or the creative content, to the extent that stays the same, you wouldn't need to file a new copyright registration for that. So again, even though they're sort of in the same project, you have trademark for the title, you have copyright for the text. Even though they're in the same sort of project, they're two different types of protection.
Yeah, the book explains a concept I teach called the open method. And at the end of the words open method, I have the little TM symbol. So that's why my question is, okay, so once everything is cleared and I have it, do I have to now re-upload the open method with a little circle R, R in a little circle and get rid of the TM? So you're saying, yes, I should do that.
Well, I mean, in a Gina, perfect world, yeah, I mean, I would say I understand your question better now. Yeah, in a perfect world, you would do that. I would say you should. I mean, but the copyright is going to be around, is going to be less about the trademark names in the text. It's going to be more about the open method in general. Right. So you would still have a claim for copyright infringement, even if the trademark information wasn't updated. So, I mean, that's a good question. I would do if it's feasible and not too expensive, but you would still have rights. You would still have rights in the copyright. Now, the other part of that is if you're publishing the book with only the TM, and people are buying that copy or using it, then it may make more sense to update the copyright because you don't want your trademark to get diluted because you're using the TM instead of the R.
I see.
So I would say, it's probably best practice would be to update the copyright with the trademark, with the new trademark.
Okay, thank you.
Yeah, and Gina, I just wanted to drive it home a little bit more that you can only use the circle R if that TM for open method went through a process of examination with the trademark office, regardless of the copyright, right? If
It
that,
is, and it is, yeah.
perfect. And then so if it goes through this process, open method as a viable trademark, and you get it, then yeah, of course you should start
Yeah.
in your next republishing, you should start using the Circle R, you know?
Yeah, I don't
Right.
think it would affect the strength of your copyright, but it could affect the strength of your
Yeah.
trademark.
Yeah.
And
Right.
so I would update whatever it is that you're selling to include the R symbol after the trademark has been issued. registered.
And you're saying also get the copyright of the entire book updated.
You can. I mean, it's
Okay.
not so expensive to do. But that's like the best scenario.
Right. Okay, thank you.
Thank you. Thank you for those questions. Michael, we'll get to yours in a second. Let me just move on to the next myth. Perfect. We just kind of talked about it a little bit. I may have given this away. Artificial intelligence can be a creator of a work for copyright purposes. I kind of said the answer before. Myth or truth? Artificial intelligence, like ChatGPT, can be the creator of a work for copyright purposes. Well, yes, it is a myth. I did just say that before. As we stand right now, a copyright must be created by a human being. What about this one? A single patent. Oh, and by the way, let me just hold on. Let me go back to that for a second because I kind of briefly mentioned it as well. And we talked a little bit about it a few weeks ago. Just check out that presentation. But artificial intelligence cannot also be the inventor of a patent, right? So patents are filed in the names of inventors. So if you went onto ChatGPT and you say, invent me a new tool, or help me invent a new spaceship or something like that. And ChatGPT gives you all these concepts and figures and all that kind of stuff. And then you actually file that with the patent office. As we stand today, the patent office, like the copyright office, has said that artificial intelligence must be a human being. I know that is pretty sad for all of you that think artificial intelligence should have rights. And they might be one day a world that we exist where robots have rights too. But right now, they do not have the right of intellectual property. They cannot be a creator or inventor. They cannot be a creator of a copyright, and they cannot be an inventor of a patent. Any thoughts, Rich?
No, I generally I agree with that. I mean, the Copyright Office is, taking public comment now on guidelines with respect to this issue. I kind of I support creators in this debate. I think if AI is going to be able to take information that a creator creates and use that to create something else, then I think that the creator should get compensated for it in some way. If if we didn't have all of the information on the internet now that was created by people, then there would be no AI. There would be no basis for that. And it concerns me when we have large companies that are taking taking all of this human knowledge and they're reforming it, and they're making billions of dollars, but the people who created the basis for this are really not getting much. And there has been a lawsuit filed by the New York Times on exactly this subject because OpenAI, which is the ChatGPT company, started appropriating all of the New York Times articles and using that to in the AI program. And the New York Times, of course, is like, well, hang on, we created all this, we should get paid for it. So at least OpenAI is now at least negotiating, some compensation for some large creators. But there's also a lot of small creators, though, who don't have that market power. So anyway, I'm very opinionated on this topic. Don't get me going. So
Yeah, no, it's a definitely moving target. Listen, I'm a huge fan of, artificial intelligent movies where, AI, takes over the world or just does great things. And so I do think we will be we will be approaching that future pretty soon. And so this is a kind of prerequisite issue as to the rights of AI. Matt has a question. What if your use of AI is a tool that helps you with 30% or less of the creation? 70% is attributed to the real intelligence of the creator. That's an interesting scheme, but again, right now, any sort of use, no matter the percentage, that is attributed to AI cannot be patented or copyrighted. That may change, and Matt, this may be the model that we turn to, right? Maybe there will be a percentage threshold as to how much is acceptable percentages for artificial intelligence to be an inventor. Rich, thoughts?
I think that's actually that's part of the discussion now with the Copyright Office, and if there's like percent AI, then the copyright would not be applicable to the AI created part, but you could get a copyright on the human created part. But that's going to be a real challenge to unwind all of that. How are you going to do that? And then, how are the courts going to interpret this, right? So one of the challenges I think will happen is that to the extent that intellectual property is created by AI, and then somebody tries to enforce that copyright, well, what's going to happen? How are judges and juries going to react to this? So, I think there's a long way to go before there's clarity on this in the law, but AI is here to stay, and it does offer amazing benefits. So,
Right.
I guess we just have to wait and see what happens.
Yes, wait and see approach for sure. Next myth. A single patent will help me monopolize the market. I own the patent on my technology. I have complete monopoly over the market. Myth or truth? What do you think? Wendy with myth. Myth, myth. Truth. R. Ellison says truth. Interesting. It depends. Peter, that's a very famous lawyer answer. It depends. But I think in the way that it's drafted, a single patent will help me monopolize the market. It is a myth. I always say to people, you cannot rely on just a single patent to monopolize an entire market. Maybe a few years ago, maybe it depends on the technology, but we always look at intellectual property as a fence around your property. So the more patents you have, the more trademarks you have, the more copyrights you have, the harder it will be, the easier, the harder it will be for someone to come into your property without asking your permission. If every patent and trademark and copyright is a gate around your property, then it's going to be hard for that person to get into your property without asking you permission to come onto your property. That's one way of kind of looking at it. If you only had one, they can go over it, under it, left of it, dig under it, to the side of it, whatever. And so that's kind of what we were trying to illustrate. Rich, you might have thoughts on this.
Yeah, I mean, I think that's usually the case. Sometimes one patent can be the killer patent, right? I mean, in the pharmaceutical industry, the active ingredient for a medication is often protected by one patent. But the goal is to create a portfolio that's appropriate for your product, for your market, and for your budget, right? And so most of the time, products change, technology evolves, and so you want to make sure that you capture those new innovations with more intellectual property, right? And so, but you have to start someplace, and for most entrepreneurs, filing that first patent is a step forward. And hopefully your business grows to the point where you can think of investing in additional intellectual property. So, David, I think I mentioned I have a hard
You
stop
do.
at 1 o'clock. So I'm going to say thank you now to everyone before I jump off. It's been a blast for me, and you guys can continue however David. So please keep everything going. So until next time, take care, everyone.
Thank you,
Bye-bye.
Richard. Thank you, thank you, thank you. Yes, Rich has a meeting. We'll do probably one or two more. And then we will call it a day. This is a pretty, we get this a lot. You might have heard this. The poor man's patent. Or the poor man's copyright. If I mail my patent idea or my creative work to myself, then I automatically own that idea. We still have clients today that will literally come into the office with their self-addressed envelope that has their patent description in it or their artwork. Is this fact or fiction? The poor man's copyright, the poor man's patent. Fact or fiction? What do you think? Fact, Gina Calvano says. Interesting. Anybody believe this is fiction? What do you think? Wendy, fiction, fiction. Yes, it is fiction. It is not. Make no mistake about it. Nobody in the world cares for a patent now. Nobody in the world cares that you have been working on anything until you file a patent application. It is what we call the first inventor to file. And so this idea that you can take your patent application that you probably have not filed with the patent office under this hypothetical and mail it to yourself as proof that you have invented it might be true, but it's not true to show that you filed it. And that's what you need in order to have maximum protection in this world. You need a filing date. And the same thing with the creative work. You need to register that work with the Copyright Office. Hang on one second. I want to just get a drink of water. So yes, it is fiction. For all of you that have done that, just register that envelope with the Copyright Office. That's the best protection. Take that patent application and file it. I think we just have a few more. Let me just see how many more I have. 1 second. Excuse me. Yeah, we have a few more. Hold on 1 second. I don't think I'm going to do them all, but let's do this one. This is going to be an interesting one. Hold on. Let me just share my screen again. Mosh, can you get me water? Okay. Here we go. Okay. Sorry about that. Here we go. I can only infringe someone's trademark or patent if I knew about it. I can only infringe someone's trademark or patent if I knew about it. Fact or fiction? Total fiction, yes. Yes, fiction. It doesn't matter. That's not a thing. You can't say, oh, I didn't know. It's the kind of the same thing with the law. Like you can't drive drunk and then get pulled over and be like, oh, well, I didn't know. I didn't know that I can't drive drunk, or I didn't know that that was stealing. I didn't know that that was infringement. I didn't know that the person had a trademark. No, none of that. None of those excuses work. Basically, this is you are under an obligation, basically, to as a competitor or as somebody that wants to use a particular technology or wants to build a particular technology. It is your obligation to find out if there are other trademarks that might be similar to yours, if there are other patents that might be similar to yours. Usually the first step in the journey of intellectual property is we do these worldwide patent searches, and we do these searches within a particular country to really determine whether somebody exists before you, or whether somebody has filed for a trademark before you, because that knowledge is important so that it can, clear you from potentially being accused of infringement later. Let's do another one. I need a registered patent or trademark to market or sell in another country. I need a registered patent or a trademark to market and or sell in another country. Myth or truth? Truth, truth, truth. Interesting. I need a registered patent or trademark. I guess it's kind of, let me break this down a little bit. So the way that I wrote it, I need a registered patent or trademark to market and or sell in another country. I wrote that it's a myth. Let me explain why. For all the people that said truth, and I think you'll probably, I think I kind of understand why you might have said truth, but the way that it was written, it's a myth. There is no requirement that you have a patent or a trademark in order to sell or market in another country. Of course, you want, right? There's no legal requirement that you have a patent or trademark to sell in a particular country. You can do whatever you want. You can market wherever you want. You can sell wherever you want. But what you will not be able to do in that country where you do not have a patent or trademark is you will not have the ability to stop someone in that country from infringing your patent or trademark. Patents and trademarks are territorial, meaning where you file is where your protection is. And so if you don't file, you're just not protected, but you can still market or sell. If I don't have a patent in China, but I can still market in China, I can still sell in China, I just won't be able to stop a Chinese infringer in a Chinese court of law, because in this hypothetical, I do not have the corresponding Chinese patent or trademark. Of course, you want to have a patent and trademark in the countries where you're marketing and selling for maximum protection, but make no mistake about it. Most of our clients are entrepreneurs and startups, and nobody has that much money to file in every single country where they want to market and sell. They just don't have it. And they don't have the ability to file it. And so, of course, you can sell in another country. Of course, you can market in another country. You just won't have the ability to stop someone else in that country from infringing your patent and trademark. And maybe that fact alone may prevent you from filing, from marketing and selling in that country, knowing that you can't do anything about a potential infringer. But in most cases, it doesn't, because the amount of money you can make in that country might actually fuel some of the infringement actions you'll need in the countries where you actually have patent and trademarks. And it is the same with copyright also, Lucy, to answer your question. But a lot of countries in the world do not have copyright protection. It's just not a codified thing. But yes, in countries that respect and understand and have copyright laws, it's the same thing. If you make no mistake, I guess the lesson of today is that the registered patent, trademark, and copyright buys you access to get into a court of law. And I'm not asking you to sue anyone, but having the ability to go into a court of law in a particular country might be enough deterrent to stop infringers in that country when compared to not having the registered patent, trademark, or copyright in that country. And to the next question, what about internet sales? All part of it, right? Like when we talk about territorial intellectual property rights, we're not just talking about the border of the United States where your protection is, or the border of Canada where your protection is if you have a Canadian patent and trademark registered, but we're also talking about digital borders as well. So if you're making internet sales and those sales are resulting in services or products delivered to a particular territory where you have the corresponding patent and trademark, that's when your intellectual property rights are added to maximum to keep people out of digital and actual physical borders. So yeah, you can market and sell anywhere, but better to have the patent and trademark along with it. Peter, I want to get to your question for a second. It's because it's kind of related to the other one. What is the typical cost range for having a patent or trademark search done? Listen, I think it depends on who you work with, Peter. I think it depends on the type of firm you work with. It depends on how big or small they are. It depends on whether they're engaged with entrepreneurs or not. But I think the range of a patent search, a worldwide patent search, probably anywhere from, I would say, 1,000 to 1,500. For a trademark search, I mean, non-law firms that offer them for $200, but at a law firm, I think you're probably going to pay anywhere between $550 and $1,000 to do a trademark search. So it depends. I think everybody on this call needs to kind of shop around, and hopefully you're not going with just the cheapest price, but you're also going with, the actual relationship that you might make with the firm. So someone can copy, plagiarize your work, book, or story in another country, but you are better protected with copyright, trademark. Yes, someone can. But make no mistake, Lucy, infringement will happen. People will copy, people will plagiarize, people will infringe. That is unfortunately the world that we live in. There are gross and nefarious and evil people out there that do these types of things. But the only way in the world to stop them, the only way, is to have the registered patent, trademark, or copyright, period. Because that allows you the ability to go into a court of law or threaten to go into a court of law and literally stop that person. Without it, there's nothing we can do. If you come to us and say there's an infringement and you don't have the patent, trademark, and copyright, then you can't use the word infringement. You can't do that. That's only if you have a patent, trademark, or copyright. So yeah, people can do whatever they want in other countries, but hopefully under certain treaties around the world and certain international protections that you can get for your patent, trademark, and copyright, you will be able to stop those people. Okay. Next myth, and I think this will be, I kind of said this already. AI can be an inventor for patent purposes. No, we talked about that. I didn't realize that I had a whole thing on it. But no, an AI cannot be an inventor for patent purposes as of now. I think this might be, I think I have a few more, but I may be, for the interest of time, I'm gonna stop at this one, our last one. A trade secret is the same type of protection as a patent. A trade secret is the same type of protection as a patent. Fact or fiction? Yes, myth, fiction. I like it. Yes, correct. That is complete fiction. A trade secret is the opposite of a patent. A patent is the most public expression of the thing that you're trying to protect in science, in chemistry, physics, biomechanics, electrics, whatever. Everybody will know exactly the way that you do it. And that's the beauty of it, because anybody that's potentially infringing you will be falling into the definition of your most public patent description. But a trade secret is the complete opposite. Nobody will ever know the way that you're doing it. It will never be public. It will never be registered. It will be only between the people you share it with under a non-disclosure confidentiality agreement. The secret sauce, exactly. It is, and so it is the opposite. Patents are public, trade secrets are not. Patents are registered, trade secrets are not. There is no United States Trade Secret Office. Patents only last 20 years. That's it. Exclusive monopoly for a limited time. Right out of the Constitution. A trade secret can conceivably last forever as long as it's still a secret between the people that you shared it with that are under a written non-disclosure agreement. Coca-Cola has their trade secret for over 100 years. But the biggest and vast difference is this idea of infringement. There is no trade secret infringement. Those words don't go together. Legally, they don't go together. There is patent infringement. If you have a public description of your invention and you believe that a competitor is doing it in a similar way to you, then you have to say to that person, it doesn't matter how you're doing it, it's similar to what I have as a public document. And so you are potentially infringing me. And I can keep you out of my property. If you want in, then you got to pay me a license. But with trade secret, there is no, oh, I have a secret sauce and I believe there's a competitor that's doing it in the same way as I. And so you go complain to someone like me and say, can you sue them for trade secret infringement? No, there is no trade secret infringement. That person could be doing it in the exact same way as you. And if there is no evidence that they stole it from you, that they misappropriated from you, then there's nothing that you can do about it. Coca-Cola cannot do anything to Pepsi. They both have trade secrets. Google cannot do anything to Bing or Yahoo for their search and ranking algorithm, also a trade secret, not patented, right? Kentucky Fried Chicken can't do anything to Popeyes. And so these are all companies that have decided to keep something a trade secret, and the only protection they have is if somebody steals it from them. If there is no evidence of somebody misappropriating it from them, then there's nothing they can do about it because there is no trade secret infringement. There is no, I have this, and I think you're falling within the definition of it. That's a patent. I have this. It's public. Everybody knows about it. And literally, you are falling within the definition of my most public technical document. So that is it, I think. Hold on, let me see. We have like a few more, but I think it's time. I won't go to the next one. I want to thank all of you for coming out again, for the people that have been here before. That we may have a part 3. If you have particular myths that you want to kind of debunk, let us know. We are having a March ESS. Of course we are. We try to have one every month. And I think it's going to be a real interesting one. We haven't done it for a few years. We basically have invited 3 entrepreneurs that are just killing it with their startups. They're, highly invested in. One of them is in the food space, one of them is in the software space, and the other one is in the consumer product space. And they're all just going to tell their stories, what they did right, what they did wrong, a little bit about intellectual property for sure. And so that will be, again, the last Thursday of March. So March 28th, be here. You'll see, by the way, this has been recorded. As you know, we will send out a recap. We will send the recording. We will share. We'll be on our YouTube site, and we will give you information as well for the March one. So thank you everyone for coming out. I really appreciate you being involved and kind of answering the myths and truths. And I hope you all do well, and be in touch if you need anything. And good night from Gearhart Law. Good evening from Gearhart Law. We'll talk to you soon. Thank you so much.